Hello, my name is Suvarna Mandal, and I'm a partner at Sai Krishna and Associates, a Tier 1 full-service law firm in India. My practice focuses on guiding domestic and international clients on technology law and trade and regulatory compliances. These are exciting times. Thanks to the leaps in AI technologies, we are on the cusp of witnessing groundbreaking changes in the digital space and our lives generally. The use and advancement of AI are growing globally at an unprecedented pace, with India playing a vital role in accelerating its development. According to recent surveys and research, India is amongst the countries with the most extensive adoption of AI and ranks first in the adoption of generative AI across the Asia Pacific. Over the past decade, the Indian regulatory framework has evolved significantly to accommodate emerging technologies while focusing on information accessibility. In this session, I will outline the policy initiatives and legislative reforms undertaken by the Indian government to regulate emerging technologies, including AI, while balancing public interest principles of access, autonomy, transparency, and accountability. The Indian government acknowledges AI's significance and its societal impact, and various ministries are developing strategies for it. For instance, in 2015, the government launched the Digital India Initiative with an emphasis on emerging technologies, including AI. In 2018, the government's public policy think tank Niti Aayog published the National Strategy for Artificial Intelligence with the brand AI for All, outlining India's approach to harnessing AI for social inclusion and economic growth. The underlying theme of this strategy is fairness, accountability, and transparency, which is integral for policy development in any field. Lastly, the Making AI in India and Making AI Work in India initiative of the Indian government has approved the India AI mission to build a comprehensive AI ecosystem that fosters innovation. It has also launched a national AI portal, which is a one-stop resource for all AI initiatives in the country. Although there are ongoing discussions on how to regulate AI in India, no specific law exists yet for regulating it. In 2023, the government proposed a new legislation, the Digital India Act, which seeks to provide effective regulatory measures while safeguarding innovation across emerging technologies such as AI, machine learning, virtual reality, augmented reality, etc. The proposed legislation will also purportedly incorporate algorithmic transparency and accountability to ensure the ethical use of AI tools to protect user rights and choices. In the absence of an overarching law for regulating AI, the Indian government and courts have applied the prevailing legal framework to AI technologies. While the principles of autonomy, transparency, and accountability have been incorporated in the legal framework generally, the government now seems to be proactively adopting these principles by introducing new laws or amendments in laws. The most recent example of this progressive approach is the introduction of the Digital Personal Data Protection Act, or the DPDP Act, which is the first comprehensive legislation governing data protection in India. The DPDP Act ensures transparency by introducing requirements of providing notice to a data principal, that is the individual to whom the data relates to, informing them about the personal data collected, the purpose of collection, and the manner of exercising the rights. The law also mandates providing access to the notice and request for consent in English or any of the 22 languages listed in the Indian Constitution. The DPDP Act also ensures autonomy of data principals by empowering them to exercise rights such as the right to access information, the right to correct, complete, and erase personal data, the right to grievance redressal, and the right to nominate someone for exercising their rights in the event of death or incapacity. While the DPDP Act primarily deals with data protection, its provisions and underlying principles can also be applied to address privacy concerns associated with AI platforms. Under the Information Technology Act, there are rules for online intermediaries, which in short are called the IT intermediary rules. These rules, amongst other things, prescribe due diligence obligations of an online intermediary, like a social media platform or an e-commerce marketplace. From a transparency and accessibility perspective, these rules require an intermediary to prominently publish on their website, mobile application, or both the privacy policy and user agreement in English or any of the 22 languages specified in the Constitution. The rules have also introduced various measures for online gaming intermediaries to promote transparency in gaming platforms by having verification of accounts, display of measures and terms for deposits, refunds, and winnings, etc. From a consumer law perspective, there are guidelines for prevention and regulation of dark patterns. These ensure transparency and autonomy for consumers as they prohibit any deceptive practice or design in user interfaces of online platforms, such as trapping into subscriptions, creating false urgency, disguised advertisements, etc. Similarly, there are guidelines for prevention of misleading advertisements, which safeguard and prevent consumers from being deceived, ensure transparency and fairness, and enable them to make informed decisions based on facts rather than false narratives and exaggerations. There are also consumer protection e-commerce rules, which requires every e-commerce entity to display various details and information, including their headquarters and branch addresses, their contact details of customer care, grievance redressal details, etc. These rules also require explicit and affirmative user consent for use rather than automatic consent. India also has the Rights of Persons with Disabilities Act, which ensures the dignity, autonomy, inclusion, equality, and accessibility for persons with disabilities. The Act empowers the government to lay down guidelines and standards for accessibility of information and communication technology products and services, and both government and private organizations must adhere to these accessibility requirements. Recently, various private entities have been directed by the concerned authority to report on the accessibility of their digital platform for individuals with disabilities and submit an action plan to address these issues. All of these efforts underscore the evolving commitment to transparency and autonomy in legislation and policy making over time. While AI is a great tool to propagate information access, it comes with its own set of challenges. The unauthorized use of individuals' personal data for testing and developing AI solutions and large language models can lead to data protection and privacy concerns. Misuse and mishandling of personal data has cybersecurity risks and would also undermine individual autonomy. Furthermore, the unauthorized use of copyrighted works by AI models infringes on creators' rights when their work is plagiarized and imitated by AI tools. According to the Indian government, the current intellectual property laws are equipped to handle such cases, yet the government purportedly intends to introduce provisions in AI-related regulations to protect content creators' commercial and creative interests. AI tools and deepfakes is another issue which can create and disseminate false and misleading information. Recently, India has seen a rise in deepfakes and misinformation, with celebrities' traits being commercially exploited without consent, leading to a surge in litigation over celebrities' publicity rights and right to privacy. Another issue with AI models is the black box problem, which refers to the lack of visibility of the internal workings of AI models. While the inputs fed and the final outputs can be assessed, the system's code or logic that produced that output cannot be examined. The black box issue therefore raises significant concerns with transparency and liability in case of any violations of the law. Finally, AI stressed with algorithmic bias is well known. In the Indian context, creating and utilizing unbiased data sets that reflect and adequately represent the diverse nature of the Indian population, considering different cultures, languages, religious beliefs, etc., is essential in ensuring fairness when deploying and regulating AI in India. However, how this can be practically achieved is a big issue. As one would expect, real-world applications and adoption of AI tools and technologies for greater access will have its own set of problems, particularly given the need to balance innovation and business while ensuring the rights and interests of individuals are protected. Given the rapid evolution of the digital space, India is taking legislative and policy measures to catch up with emerging technologies and is proactively devising action plans to foresee issues and risks when drafting laws to make sure that they are future ready. What remains to be seen is how it seeks to uphold the principles of transparency, autonomy, and accountability. I hope that this session has provided some insight into the regulatory landscape in India concerning AI and information accessibility. Thanks a lot for your attention.